वेलकम टू लीगली लीगल। आज हम पढ़ेंगे इंडियन कॉन्ट्रैक्ट एक्ट के बारे में। स्टार्ट करते हैं उसके बेसिक्स से। व्हाट इज अ कॉन्ट्रैक्ट? सो एनी कमर्शियल एक्टिविटी requires an understanding among the people concerned. This understanding is often reduced into writing to give effect to the intention of the parties. Such formal versions are known as contracts. These contracts define the rights and obligations of various parties to facilitate easy performance of the contractual obligations. तो जो ये इंडियन कॉन्ट्रैक्ट एक्ट है ये कोडिफाई करती है द लीगल प्रिंसिपल्स दैट गवर्न सच कॉन्ट्रैक्ट्स. द एक्ट बेसिकली identifies the ingredients of a legally enforceable valid contract in addition to dealing with certain special type of the contractual relationships such as indemnity, guarantee, bailment, pledge, etc. etc. As you can see in this diagram, it clearly states that while all contracts are agreements, all agreements are not contracts. An agreement which is legally enforceable alone is a contract. Agreements which are not legally enforceable are not contracts but remain as void agreements which are not enforceable at all, or as voidable agreements which are enforceable by only one of the parties to the agreement. Therefore, we can say that an agreement is a promise or a commitment or a set of reciprocal promises or commitments. An agreement involves an offer or proposal by one person and the other person. After accepting such offer or the proposal, it makes an agreement. If the agreement is capable of being enforced by law, then it is a contract. अब हम आते हैं essentials of a valid contract पे. So, Section 10 of the Act defines that all agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object and are not expressly declared to be void. Thus, in order to create a valid contract, there should be the elements that should be present. Let's discuss those elements. Number one is offer and acceptance. So, in the first place, there must be an offer, and the said offer must have been accepted. Such offer and acceptance should create legal obligations between the parties. This should result in a moral duty on the person who promises or offers to do something. Similarly, this should also give a right to the promise to claim its fulfillment. Such duties and rights should be legal and not merely moral. Now, this case of Balfour versus Balfour, there was a husband who promised to pay maintenance allowance every month to his wife so long as they remained separate. When he failed to perform this promise, she brought an action to enforce this. So, as it is an agreement of domestic nature, it was held that it does not contemplate to create any legal obligation. The second element is consent of the parties. Consent basically means the knowledge and approval of the parties concerned. This can also be understood as identity of minds in understanding the term via consensus and idem. Further, such a consent must be free. This consent would be considered as a free consent if it is not vitiated by any coercion, undue influence, fraud, misrepresentation, or mistake. Wherever the consent of any party is not free, the contract is voidable at the option of that party. Let us take an example here. If A threatened to shoot B if he does not lend him rupees 2000 and B agreed to do it, here the agreement is entered into under coercion and hence voidable at the option of B. The third element is the capacity of the parties to make a valid contract. Capacity or incapacity of a person could be decided only after reckoning various factors. Section 11 of the Indian Contract Act elaborates on the issue by providing that a person who, number one, has not attained the age of maturity, number two, is of unsound mind, and number three, is disqualified from entering into a contract by any law to which he is subject, for example, convicts, etc., they should be considered as not competent to enter into any contract. The fourth element is the presence of a lawful consideration. Consideration would generally mean compensation for doing or omitting to do an act or a deed. It is also referred to as quid pro quo, that is, something in return for another thing. Such a consideration should be a lawful consideration. You can see the example on the screen. The last element to a contract is that the agreement entered into for this purpose must not be which the law declares to be either illegal or void. An illegal agreement is an agreement expressly or impliedly prohibited by law. A void agreement is one without any legal effect. For example, a threat to commit murder or making or publishing defamatory statements or entering into agreements which are opposed to public policy are illegal in nature. Hence, they are often considered to be void. So, that's all for the day. I hope to see you again. If you like our video, please like, share, and subscribe our channel.